Good morning, everyone. Let the record show that we have a quorum present, and I'd like to call the meeting to order. And I'll ask the clerk to invite in the first witness.
I swear by Almighty God that the evidence I shall give to this Honourable Legislative Assembly shall be the truth, the whole truth, and nothing but the truth.
I swear by Almighty God that the evidence I shall give to this Honourable Legislative Assembly shall be the truth, the whole truth, and nothing but the truth.
Good morning, Ms. Rishma. And when you ask the first question, just say your name and your position so that it'll appear in the record.
Yes, sir.
Okay. At this time, I'll invite, we are discussing today the Auditor General's report on the government's use of consultants and temporary staff. And at this time, I'd invite the Auditor General to give a few opening comments on the report, and also, if possible, give the committee a short update on how the audits for 2017 are progressing.
Good morning, Mr. Chairman, PAC members, ladies, gentlemen. Thank you for the opportunity to make some opening remarks, both about the report and update on the 2016-17 audits. If I start with the report, I'd like to begin by taking the committee through the reason for conducting the audit work on use of consultants and temporary staff, discuss some of the key findings, and highlight how we believe government could use these reports to improve how it manages public resources. The performance audit reviewed how effectively government manages its use of consultants and temporary staff to ensure that it is obtaining value for money. The audit focused on core government only, that's the ministries, the portfolios and the offices, so not statutory authorities and government companies, although the recommendations are equally relevant. Our findings on the government's use of consultants are based on the review of 23 consultant contracts between July 2012 and the 30th of June 2017. These 23 contracts accounted for 42% of the government's total spend on consultants over the 5-year period. Firstly, I think it's worth saying that using consultants and temporary staff is a very reasonable thing for governments to do, and there are many good reasons why you would want to use consultants and temporary staff, including bringing in specialist skills or managing peaks in workload. However, the use of them needs to be properly planned and well managed to ensure that value for money is obtained. Our audit found that government does not routinely monitor how much it is spending on consultants or temporary staff. And so my colleagues to the left had to pull together the information from the government's financial systems and analyse it. As a result, we estimate that the government spent 34.9 million on consultants and 3.6 million on temporary staff, a total of 38.5 million over the 5-year period. We also analysed government spending on consultants year by year, and spend fluctuated on an annual basis as we'd expect, with 3 ministries accounting for over half of the total spending on consultants, 5 types of consultancy service accounting for 80% of the total spend, and the top 10 suppliers, government spent more than 8.1 million with 3 of them. All of this analysis can be found on pages 10 to 15 of our report. Our audit found that the government has made progress in implementing the new procurement practices since my office last reported on this subject in 2012. And indeed, you'll be aware that the new procurement law came in a couple of days ago, along with supporting regulations. It's pleasing that of the reviews we did, 7 out of the 8 government entities we reviewed had procurement manuals in place, with the exception being the portfolio of legal affairs. We noticed that in some cases there was scope for further improvement, rather unsurprisingly, and that includes sort of potentially using specialists when negotiating contracts, and also around the range of procurement methods that are used. Despite these improvements, we found government does not consistently consider value for money when engaging consultants. The guidance requires that business cases be prepared and approved for all procurements over $10,000. And invitations to tender or requests for proposals should be used for open procurement, and we'd expect open procurement to be used for the most part. Our review of the 23 consultant contracts found that only 6 business cases were prepared, despite all 23 contracts being over $10,000, and that those that were prepared could have been better and more comprehensive. However, on a positive note, most of the 23 contracts went through an open procurement process. We did identify 5 contracts awarded through single source procurement that in our view should have been subject to some form of competition. Our review of contracts identified that the government does not have standard terms and conditions, and that generally they are accepting the supplier's terms, which poses a risk to value for money. My office made a recommendation in 2011 that the government should develop guidance on setting out the circumstances when an entity should seek legal advice or assistance in preparing contracts. This has not happened, and it's also not clear whether contracts have been subject to legal review prior to signing, as this is at the Chief Officer's discretion. Further considerations in obtaining value for money are effective contract management and post-project evaluation. We found that the government does not formally manage and evaluate the performance of consultants once they are appointed, and there were very few examples of post-contract evaluation to learn lessons for the future. Finally, our report discusses the government's use of temporary staff, and these being staff that are employed through recruitment agencies or individual contractors. Over the 5 years we reviewed, as we said, the spending on annual temporary staff was 3.8 million, which is more than double the 1.2 million in the 12 months to the 30th of June 17. Government could not provide us with an explanation as to why spending had increased to 1.2 million over the 12 months to June 17. Neither does it have any guidance on procuring or managing temporary staff. Our report includes 16 recommendations that are set out in Appendix 3 on pages 42 to 53 of the report. We believe if they are implemented, this would improve the government's use of consultants and temporary staff. And I have with me today people you're familiar with, Angela and Julius as the director and manager of the audit, and then Gabriel Nukubi in the end, who has provided most of the input to the field work from my office. Thank you. And the update on the financial audits, nearly forgot. So it's been another positive financial audit season while we've been auditing the 2016-17 financial statements, with the statutory deadline being the 30th of April. All 44 public sector entities submitted their financial statements by the statutory deadline of the 28th of February, with one exception, a bit like last time, we can't quite get the 100%, one exception. Cayman Islands Stock Exchange. It was a complicated season for preparers and auditors, partly because it was an 18-month period because of the change in the financial year, so obviously the additional time in itself presented complications. But more significantly, because of the election, there are not a lot of post-government reorganisations between entities, and that impacted on opening balances, closing balances, budget analysis and all sorts of things that are required. We had the implications of the Public Authorities Law to consider and various technical matters that arose during the course of several audits. By close today, we anticipate we'll have 30 audits completed and that 4 of those will be qualified, with the remainder being unqualified. I think the committee will be particularly pleased to know, given their witness hearings in February into the qualified accounts from 2015-16, that judicial administration, where Suzanne Boothwell's the court administrator and Tiffany is their CFO who's supporting Reshma today, have gone from a qualified opinion to an unqualified opinion this year, so that's particularly pleasing. And similarly, the National Gallery for the Cayman Islands, where you had a witness session on the 22nd of February, have also gone from a qualified to an unqualified audit opinion. And I just thought the committee would be particularly pleased, given your interest, to know that. I'd like to pay tribute to the guys behind in the Financial Secretary and all in the Ministry of Finance and Economic Development, who continued to lead by example, being the first to have their audit completed, and of course it was unqualified. That was signed off on the 8th of April, which is approximately 2 weeks earlier than the equivalent for 15-16. So that's really positive. And finally, I'd like to pay tribute to all my audit staff, our private sector audit partners, and the finance teams across the public sector for their commitment and hard work in trying to achieve all the statutory deadlines. We didn't manage it across the board, but it's not in spite of incredibly long hours, consistent commitment over recent months from an awful lot of people. And I do anticipate that we will be signing off an awful lot more over the next week or so. Thank you, sir.
Thank you for that interim report on the audits, and it's good to hear that we're progressing in the right direction, and hopefully by next year we'll get that 100%, and then we'll get even in the submissions as well as 100% unqualified. But it's good to know that the people who came here in particular took that opportunity and that exercise and fixed their problems. So congratulations to you all. Having said that, you're here today to deal with the consultant services from the portfolio of legal affairs. It looks like you all had the biggest spend of all of the entities that the Auditor General reviewed. You all spent 8.2 million, or 23% of the total. And over that 5-year period, and we would like to have some explanation as to why the portfolio of legal affairs has so much consultancy fees.
Mr. Chairman, before I begin, would you permit me to just read a brief statement?
No, the committee decided almost 2 years ago now, because people were using the statements for the wrong purposes, and I'm not saying that that would be your intention, but we got into situations where people were using the opportunity to make statements to level personal attacks at the audit office and other stuff. So we just put down a blanket rule: no statements. You're here to ask questions. You can use whatever part of your statement and answer the question that you see fit. And we can accept that, but we don't allow statements which would preempt what we're going to ask.
Understood, Mr. Chairman.
Okay.
Thank you.
All right. So if you could just give us an overview of what you use consultants for, what they represent, and why the cost is so high.
So, Mr.
And then we can
Chairman,
drill down after that.
certainly, Mr. Chairman. So, at page 14 of the Auditor General's report, reference is made to the portfolio of legal affairs and the spend of 2.7 million, which represents 33% of the total expenditure on consultants over the 5-year period. For the portfolio, this was on legal services, as is stated in paragraph 21. In looking back over that period of 5 years, there was a significant volume of what I would say unprecedented litigation arising out of the tempura matter, which had started from around 2007 up till 2009. And there were a number of cases that were all interrelated. And if I may say, that was probably an exceptional period of time in the context of that investigation and then the litigation that it spawned. So that would account significantly, if not predominantly, for the expenditure over that 5-year period.
The majority of the funds is spent hiring lawyers for court work.
Yes, Mr. Chairman.
Why is that necessary when we have a full staff legal department and they seem to be earning QCs in that department at an alarming rate?
I think looking back at it, it was the complexity of the issues that were raised, and that's one of the considerations that's taken into account when a determination is made as to whether there is a need to engage external consultants. I think the demands on the department at that time as a result of those cases were quite significant. In addition, we'd had a previous member of staff within the chambers who had been involved at the early stages. He left the chambers in 2013, so for continuity, having regard to the volume of work that had already been done, it was deemed appropriate to have him then continue on even after he had left the chambers. And similarly, the Queen's Counsel, who had been instructed to lead, he continued his services as well. So that extended over that 5-year period.
They probably don't want to tell us which court case it was. Yeah. Was that one of the tempura cases?
Yes, Mr. Chairman.
And so the person was retained to continue the case at cost above what he was paid as a staff member? Or?
I would need to confirm the rates that were being charged in comparison with the salary, Mr. Chairman, and I can provide that information to you. But you've asked in terms of the case. One of them I can cite was the matter of Kernahan against the Governor and the Attorney General and others, and that was instituted in 2009. Then there was in 2011 another case, and that was Kernahan and the Attorney General against Bridger. There was an application that was then filed in London by the Commissioner of Police against Bridger. That was in 2012. And the Kernahan matter was eventually resolved in 2014. And there was a further application in the matter of the Commissioner of Police and Bridger in 2014. So there was a long history of these proceedings.
Does anybody know the total cost of tempura to the country?
Mr. Chairman, would that be in terms of the investigation and the financial costs, or?
Yeah, everything.
I've read, and I can't verify that it was in the region of approximately 10 million. Again, I'm not in a position to confirm that.
Oh, yeah, I think you forgot to tell us who you were at the beginning of the statement, so you can do that now.
My apologies, Mr. Chairman. Reshma Sharma, Acting Solicitor General, Portfolio of Legal Affairs.
Okay.
Good morning, everyone, and just want to thank Reshma and her team member for coming this morning. I am a little bit saddened that the legal department is actually here this morning. And the reason being is that a while back, one of the things that we are pushing for is that all government contracts should be at least signed off by a representative from the finance department and the legal department to ensure that there's some elements of protection within the contracts that government is using. When I look at page 16 and going over into page 17 of the report, just to read it briefly, it says, the financial regulations 2013 revisions state that any contract for the purchase of supplies, services, and assets over 50,000 should be subject to public tender, and for the purchase of supplies, services, and assets over 20,000, that any chief officer's opinion can be provided by only one supplier. They may be procured from a single source, subject to the overriding requirement to ensure value for money and appropriate evaluation of the supplier proposal. Then going to section 32, it says, we found that all of the 8 ministries and portfolios we reviewed, except the Portfolio of Legal Affairs, had procurement policies and procedure manuals. Basically, in a nutshell, the only entity at a ministry/portfolio level that does not have procurement policies in place is your department. And for us, where we are pushing for compliance with the various laws, whether it be the procurement law or the public management and finance law, and where we are pushing departments and everyone else to make sure that they comply with the law in terms of going out and purchasing goods and services. It's a little bit disheartening that the one department that technically should know the law is the one that is actually not in compliance with the law. And that is, I'm going to tell you, a very uncomfortable position for us to be in, because we can't sit down and be pushing for one thing, and then the legal advisors are the ones that are not following the law. So my question in all of this, through you, Mr. Chairman, is first of all, how did we get into this position in terms of, it's not as if though this is a new ministry, a new department, a new statutory authority. This is an entity that's been around for a while. The law has been around for a while. This is not something new within the law. How was this overlooked, one, to begin with, and then two, what steps are now being taken, and then three, from internal reputational standpoint, because the other civil servants looking at this and they'd probably be saying, these are the people supposed to give us advice. What are you guys going to do to fix your own internal branding within the government or the civil service to say, you know what, we are on point. But this is completely unacceptable.
Through you, Mr. Chairman, to the honourable member, you're absolutely right. We've not had a procurement manual in place. I've been acting in this post from last year, and it's one of the things that I noticed. I can't speak to why this hadn't been done previously. There was never any information or guidance provided to me on that point. However, moving forward, and in light of the recommendations made by the Auditor General, we recognize that this is an area that needs to be addressed. So we did undertake in our management response to look into this and have something prepared. It's also quite timely that we now have the new procurement law and regulations in place. I know the Central Procurement Office is also going to be issuing guidance for all of the civil service entities to follow. So we intend to put something in place to deal with this moving forward.
how do you determine any kind of consistency in your procurement of lawyers, or is it just you just accept what the person that you would like to handle the case based on whatever the guy's performance in other similar cases in other jurisdictions, or is there no format or standardized way in which attorneys are recruited to do cases?
Thank you, Mr. Chairman. What I would say is that although we've not got anything documented in the form of a manual which speaks to that, our practice has been, firstly, to do an internal capacity review. Our starting point is always to assess whether we have the capability in-house to deal with a particular matter. If there is a specialization in law, if there's a particularly technical nature, or a certain degree of expertise that might be required having regard to the request for advice or the subject of the litigation, we would consider that as well. We would also look at the likely demands that a particular request or case may impose on existing resources. In other words, is there going to be an impact on our delivery of other legal services to other clients? Is there a particular political sensitivity to the subject area? And those are just a few of the considerations we would look at in determining then, do we firstly need to engage outside counsel? If the answer to that has been determined as yes, the next step would be, how do we go about choosing the appropriate service provider? And to that, we would obviously be looking at the expertise, past work experience, if it's somebody that we've worked with, has a good track record. And I would say at this point that we tend to call upon external service providers that we've used in the past and have long-standing relationships with. We'd also look at years of experience, obviously the seniority of the individual, satisfaction from past cases that they've worked on with us, knowledge of the portfolio's needs, qualifications, reliability, and timeliness in the provision of services. So that's the standard approach, if I may say, Mr. Chairman, that we tend to use when proceeding to determine if and when external service providers ought to be engaged.
Can you give us an overview of how the portfolio of legal affairs is structured, whether you have what departments you're doing and where the majority of these consultant services goes within that structure?
Certainly, Mr. Chairman. If I can start, so the chambers are headed by the Attorney General. Below that, we have the Solicitor General, and then there are positions for 2 Deputy Solicitor Generals. They're at the senior level. Then you've got 2 Senior Crown Counsel. There is then Crown Counsel 1, Crown Counsel, there ought to be 5, Crown Counsel 2, which is our most junior. If we are operating at full capacity, that would be 12, which includes the Attorney General, who rolls his sleeves up and he gets involved himself. We tend to find that the cases that are briefed out are probably at a more senior level and therefore would warrant the bringing in of a more senior counsel rather than junior practitioners. From time to time, however, we might have a junior counsel supporting that lead counsel, if you like, if there is a particular capacity demand as well. But it's not that we tend to be bringing them in for what I would call routine or sort of institutional type matters. They tend to be more complex in nature and probably involving slightly more technical issues, if you like.
Is there a requirement in your contractual relationship with these consultants that they do in fact work with one of your junior staff for the possibility of knowledge transfer?
Sorry, Mr. Chairman. Absolutely. It's standard practice that where external counsel is engaged, he or she is going to be instructed by Crown Counsel, who's going to work very closely with that individual. That's going to be the direct point of contact. And what we've found is there is, in fact, a very valuable knowledge transfer that's being passed, but it's not limited to the instructing counsel. It's shared amongst the other lawyers in the department as well.
Sorry, just from my own understanding, and maybe the auditors can best answer this. When we say legal services, within your audit, the DPP was also included in legal services, correct? Now, I just want to understand, because I understand that the DPP is a separate legal entity to some extent. So the answers that are being given today, is it just for your section, or does it also include the spend within the DPP? I want to just understand that, just to make sure that there is no confusion.
Mr. Chairman, through you, the answers that I'm giving are for the portfolio of legal affairs and exclude the office of the DPP. One thing that we noticed from the report is there were certain statistics being given that seemed to include certain contracts that might have been done on the criminal side. I think part of the confusion may have arisen, or that may have been because traditionally we were all the legal department where we were joined, and then in 2011 the office of the DPP, Ms. Richards was appointed to that post, and I think by 2012, if I'm not mistaken, there was a physical separation of the two entities. I think there has been some reference to a few contracts in the Auditor General's report, but they relate to criminal matters and therefore don't touch and concern portfolio.
Which brings me to my next question. Then what is roughly the split? Oh, sorry.
I was just going to clarify, the spend is from 2012 onwards, when they were separate entities. If there was some confusion, it's unfortunate that through clearance those matters weren't brought to our attention, but we believe they're two separate entities and two separate areas of spend.
So the 8-point-something million that we're talking about, roughly how much of it is portfolio legal affairs and how much is DPP? Because I don't want anyone out there to believe that the full amount is all PLA when some of it should be DPP. So we're just trying to, I don't want them to unnecessarily look like they're out there spending all of this money on tempora.
Through you, Chair. Just to clarify, the 8.2 million is the total spend by government on legal services. And as Ms. Reshma pointed out earlier, in paragraph 21, we say that the portfolio of legal affairs spent 2.7 million of that. And our audit focused on that 2.7 million spend that PLA had incurred between 2012 and 2017. Of the 3 samples that we selected for PLA, we looked at one, and it was actually a contract that was for DPP but had been procured by Portfolio of Legal Affairs on their behalf. So the spend is recorded against Portfolio of Legal Affairs, even though the contract was something that they were doing on behalf of the Director of Public Prosecution.
Okay, so if we are...
Just a minute, but isn't that a conflict? Isn't the DPP and the Portfolio Legal Affairs supposed to be 2 complete constitutionally separate entities? And why would the PLA be procuring services for the DPP?
Mr. Chairman, I think part of the issue might have been, even though the split may have occurred, we are sharing our finance team, and I think I can't say if it may have been a situation where the portfolio was somehow being billed for these things, or the invoices were somehow being paid by the portfolio but then reimbursed by the DPP's office. I don't know if that was just a sort of an administrative oversight.
The Portfolio of Legal Affairs in 2012, when we separated and created the position of DPP as per the 2009 Constitution, so we're already 3 years late in getting it done, you didn't separate the finances. Are you still sharing financial services today?
That is correct, Mr. Chairman.
Why? Is that because of the restrictions in recruitment?
Shall I give a perspective?
Yeah,
It is
okay.
only a perspective, because I know Ms. Tiffany's there. Ms. Tiffany will say for herself, she's the CFO for a number of central government ministries, portfolios and offices. They tend to be smaller in their nature, and therefore, as an economy measure, it's not sensible for each to have their own finance and administration. So it should be shared, but the work they do, it relates specifically to the entities that they're serving. But I mean, Miss Tiffany will be able to say more.
Tiffany Banks, CFO for the Portfolio of Legal Affairs. I'll try my best to clarify. Of course, I wasn't there at the time, so I can't say for certain. In terms of now what happens, the Auditor General is correct that I am CFO for multiple entities. However, we do treat them separate, so separate financials, separate payments, etc. At the time, like I said, I can't speak for what was happening back in 2012. Based on what Ms. Reshma said, I know the director of the DPP was appointed in 2011. However, there was some time to physically separate. There may have been time to get bank accounts, etc., opened. Now, if I understand correctly, what Ms. Cullen said was that the contract was with DPP. I think it would be incorrect to say that Portfolio of Legal procured the services. It may have been an instance where it was paid because at the same time they were somewhat still going through the process of separating. So it may have been where Portfolio of Legal, the payment came out of there and was reimbursed by DPP. However, I don't know if it would be accurate to say it was procured by the Portfolio of Legal Affairs.
Yeah, thanks very much for that. What I'm trying to determine, because we're discussing $8.2 million spent over a 5-year period. If $2.7 million is directly for the PLA, Portfolio Legal Affairs, then is the remaining $5.5 million, is that for the DPP? I'm just trying to get a breakdown in terms of, from a constitutional standpoint, how much of it was DPP versus how much of it was Portfolio Legal Affairs?
Just see if Gabrielle or Angela can answer that, but it will be other entities as well and other ministries.
Through you, Chair. Yes, I'll try to clarify. So of the 8.2 million, 2.7 is Portfolio of Legal Affairs. And we can give you this breakdown. The next biggest spender on legal services was what is now the Ministry of Education, Youth, Sport, Agriculture and Land. Then the Ministry of Human Resources and Immigration. Both of those spent around $1.5 million over the 5-year period, and then many of the others spent money on legal services as well. There are around 4 ministries or portfolios that spent around $500,000 over that 5-year period, including the DPP, which is around 600,000, Financial Services and Home Affairs, Portfolio of the Civil Service, and Ministry of Health is a bit lower at 370,000.
Thank you, Mr. Chairman. Through you, sir, the reason why I asked those questions, just to put it in context, is that when you start looking at pages 42 onward, which is Appendix 3, in terms of recommendations, they are, like you look at recommendation number 9, for example, the Portfolio of Legal Affairs should develop framework agreements or call off contracts for the provision of legal services. I mean, what we want to make clear is that if a government department is going out there to procure legal services, we would expect at the end of the day, the only entity or area within government that have the qualifications to say this is good legal service or bad legal services would be the legal department. So we wanted to distinguish between, so even though it is, what we don't want the public to think that is that the Portfolio of Legal Affairs went out and spent $8.2 million, when in fact there were other entities that were also spending this money. So we just want, we don't want that message out there that they basically, that is what is being done. You know what I mean? So that's why we just wanted to clarify that. So now, for us, Mr. Chairman, which would mean then we would like to know what it is that education and these other ministries were spending this money on, And we also need to find out why is it that they think that they needed to go outside, or maybe you guys, well, based on the recommendation, it appears that you guys weren't even consulted. So it would be scary for us to think that if they need legal advice, and the Attorney General is the legal advisor to the government or his chambers, and these ministers are going out and securing legal services outside of what it is that the Attorney General should be doing, then I think the public and this committee also need to understand why that is being done. But you can't sit down and have a legal department to be doing all of this stuff. I mean, granted, yes, you do need consultants, but we would like to understand why they would have engaged externally for those issues as opposed to going through the Attorney General.
Mr. Chairman, through you, I'm grateful to the member for that clarification being sought on the figure of the 8.2, because we were concerned as well that the impression that the public would have was that that was a spend coming from the portfolio, which is not in fact correct. As to your point about the other entities that might have been engaging external consultants and whether the portfolio and the Attorney General had been consulted prior to that being done, I'm not in a position to say if we were. I was not in a management position back during that period of time, so I'm a little bit constrained in my ability to say with any degree of certainty if we had been consulted previously, but it may be. So I think there might be, it's something that would need to be looked into if you wish to have that input from us.
Can I ask the Finance Department? There used to be a rule in government that you had to get the legal department permission to go and engage external legal advice. And it usually had to be on the basis that they didn't have the resources to provide it, or it was such expertise that they needed to go. When was that rule changed? Under the PMFL law or what? So the rule might still be in place, it's just being ignored.
Mr. Chairman, I am not aware of such a rule actually being in place.
But I'm acutely aware of being in place because I was subject to reprimand because the HSA sought outside legal advice because at that time the Attorney General's chambers didn't present themselves in court to defend HSA at the time, and the HSA lost the case. And I was reminded in uncertain terms that we needed the approval of the Attorney General chambers to engage outside counsel. Because why would the government have this elaborate legal affairs office if any ministry can just decide on their own to go and seek legal advice from somewhere else? I mean, it would be the same equivalent of everybody deciding they can have their own computer services consultants outside when government has centralized computer services. What's the difference?
Mr. Chairman, through you. Simple, clear scenario. Been in the news. 4 people applied for a job. The one gentleman who's not qualified as the job description got the job. Caymanians appealed. The appeals tribunal said yes, the Caymanian should have gotten the job, not the English gentleman. He was not qualified. The Education Ministry has now hired a private law firm to go to court to fight the Caymanian against the Caymanian for the Englishman. Should they be consulting you? Should they be going through you? And would this money for the private law firm come through you?
Mr. Chairman, through you, I believe that matter is currently before the courts, so I would be a bit reluctant to comment on any of the substantive issues raised in it, but
Ma'am, we're not looking the information. We're just looking the procedure.
as I understand it, in that case, Mr. Chairman, through you, there was consultation between the Ministry of Education and the Attorney General's chambers in relation to the question of representation.
Can we get back though? Oh, okay, you're finished, sorry. Oh.
No, sir.
Okay. Can we get back to what progress now has been made on your establishing your procurement manual, and whether that procurement manual now is going to be the procurement manual for all the entities that you manage as CFO, or each one is going to have their own procurement manual? Huh?
Mr. Chairman, just to clarify the question, were you looking at the entities that fall within the portfolio of legal affairs, or those other entities that...
Entities that fall within legal affairs.
Our 7 departments,
Yeah.
yes. Mr. Chairman, the intention is to have a comprehensive manuals and procedures for the entire portfolio, so all 7 departments which fall within it.
Mr. Chairman, through you. So can you give us some indication of when this manual will be completed? Any time frame?
We are, I think we tentatively put in initially the beginning of May, but I think we're looking now to the end of May. The reason for that is we are exploring some of the recommendations that have been made by the Auditor General in terms of possible arrangements, such as call-off agreements with external providers. Obviously, we're requiring some input from those that we tend to call on more frequently to get a sense of if that's something they'd be willing to engage with. And we're also just trying to get a sense of how the procurement manual should be crafted in light of what we see as the sort of uncertainty of litigation, and therefore the difficulty, if you like, of using traditional procurement methods such as the competitive tendering when there's an urgent need to get legal advice or representation. So we've taken on board the recommendations that have been made, and we're trying to craft the path of how to incorporate them in a manual for the portfolio.
I don't understand part of that last question when you're saying that you're concerned about the intricacies of a particular legal case and the urgency in terms of going through a business case and a competitive procurement. You're trying to find a way to write into the manual that you don't have to do a business case and you don't do competitive recruitment, you just go to the one that you believe is the best.
To clarify, Mr. Chairman, one of the challenges that we've found is that sometimes if a piece of advice is required very urgently, or we have sort of a very short time frame within which to respond or provide a defense in a matter, it's not practical to then go to an open tendering process to try to identify a suitable provider for legal services. So in that sort of arrangement, probably something akin to a direct award might be more appropriate. So there's consideration being given to, if you like, a sort of a pre-qualification exercise whereby there are certain service providers that we would tend to engage with regularly, sort of ensure that they're fit for purpose, if you like, for the needs that we have. And I understand the Auditor General to be suggesting that that would be a type of arrangement that would allow us the flexibility to call on them as and when required, but at the same time sort of meeting the overall tendering procurement requirements.
I know in the corporate world, it is standard to have some you refer to as panel firms, where you'd have a list of companies that would have been pre-approved to provide certain, I guess, legal advice and legal services. And I think somewhere along the line, something like that should be acceptable. I think what we probably would be looking for is, in terms of the procedures, anything outside of the pre-approved panel firms is at a minimum. I think at least the cabinet at least should have some leeway, since we're unlikely to be representing government, to at least approve X, Y, Z, or have some discretion specifically for legal matters, recognizing the urgency of it as opposed to going and building a building. Because if something is moving, you need to be able to move immediately. So I think within the procedures or somewhere along the line, at least that responsibility should be given to cabinet or some responsible entity under the law.
Sorry, just for clarification, we recognise the situation legal's in and the circumstances. And if you see in the report, we were suggesting things like call-off arrangements, framework contracts. We've got our audit consultants on such arrangements, which means you go through, as Reshma said, and just pre-qualify. So you've kind of ensured the value for money in a holistic sense. We're also not in the least bit adverse to situations where a single source would be necessary. And the procurement law allows for that. It allows for chief officer discretion. The point we were making in this is that we didn't see any evidence of the correct sort of thinking and procedure. I'm sure it was there, but again, it's documenting why you've gone through a single source and.
But this is why we're concerned if you don't have any kind of standard contracts. Because how do you know you're getting value for money? Is that based on success or failure before the judge?
Mr. Chairman, that might be one indicator perhaps, but I wouldn't say that that is the determining factor of whether value for money was obtained by a particular service provider. As the members would be aware, there's always an uncertainty with litigation, and even though you may think you've got the absolute strongest case, it may just not be your day in court, and the verdict may not be what you expected or anticipated. There are rights of appeal, of course, and even after those have been exhausted, you still might not get the desired outcome. So I think we tend to look at value for money perhaps more broadly. We are looking at, obviously, the rates that we are paying for these external consultants. What we have found in our experience is that the external firms, even with the levels of Queen's Counsel, tend to be more cost-effective than those offered locally. So that's an important consideration, but generally the quality of the advice has been sound in terms of repeat engagements. I think that demonstrates the confidence and the trust that we have in the service providers, and the fact that we tend to draw on a small pool of well-known, long-standing firms that government has had these relationships with is testament to the fact that we are confident in the quality of the services that they provide. The timeliness is not an issue. They work closely with instructing counsel and they agree the time frames. So we've not had situations, or there's nothing that comes to my mind where that's been raised as an issue. So when we look at the value for money, I would just suggest we look at it a little bit more broadly than simply a win-lose scenario, sir.
I noticed from the report that your biggest supplier of legal service is HSM Chambers. That doesn't board with the argument you just gave me, because isn't that one of the newer chambers in this country and also one of the smaller ones?
Mr. Chairman, so again, putting it in context, the audit was over that 5-year period, and as I'd mentioned previously, it was a former Assistant Solicitor General within the AG's chambers who had originally been involved heavily, if not singly, with a lot of the work on those Tempura-related litigation matters. When he left the chambers in 2013 and went on to HSM, the work went with him because of the depth of knowledge that he had and to ensure that continuity of service. So that's why you'd see HSM there. And as I'd indicated previously, because of the related litigation that sort of spawned from that, he remained involved as the instructing counsel on the ground.
So, truly, Mr. Chairman, that's my own understanding. Going by media reports, they are one of the more active firms that are suing government for all of these immigration matters. So on one hand, we're giving business to somebody, and on the other hand, they turn around suing us. I mean, how do you reconcile that kind of relationship where the lawyer with one day that you're supposed to be building a good relationship is other firm turning around suing you for something else? I mean, there's got to be some conflicts, I mean, somewhere along the line. I mean, I know in the divorce cases where one spouse has retained one person, they're conflicted from doing business with the wife or something else, but how do you guys reconcile that? I'm just curious. I'm not a lawyer, I'm just curious.
Through you, Mr. Chairman, if I can assist, as I said, looking back at it, so there was that need to ensure the continuity because of the volume of work that he had put into it. It was a logical step. Again, it would have been extremely challenging and difficult if that was simply to be passed on to an existing member of the chambers to sort of bring himself or herself up to speed. But the other point that I would make is that flurry of litigation that we've seen from HSM has been in recent years, I would say, and probably in that 2012 to 14 period, I think less so, if memory serves me correctly. So it might have been, and I understand the concerns that you've raised, but it just might have been that at that point in time, it really wasn't quite as it appears now in terms of the challenges being brought by that firm against the government.
Well, recognizing the other building across the road, which is the courts, and this is a building of politicians, I'll say this much. In our business, you either fish or fowl. So if you're going to work with us, you work with us. If you're going to sue us, you sue us. But I'm going to tell you straight up, you can't be both. So I want you guys to bear that into consideration when you guys are selecting these attorneys.
Through you, Mr. Chairman, and I would just add to that that counsel is no longer employed with HSM. So,
Mr. Chairman, just through you, sir. One of the things I just wanted to make sure we clarify as the type as a loose end. We had spoke about the Ministry of Education and the Ministry of Human Resources using other legal services. Now, I note from the Auditor General's report that those ministries had policies and procedures in place with regards to procurement. So I don't want it to leave the impression to say that they went out and probably engaged legal services and then probably followed the proper procedures. So I'm going to go by the assumption that if they have processes and procedures in place and they were doing some things well, that if at least they went out and got these legal services, I will give them the benefit of the doubt that at least they probably followed the correct procedures. I don't want it to be kind of left out there because I know we touched on it, but we never kind of closed it up. And I don't want to leave the impression with the public as if though the ministry did something that they shouldn't have done or whatever. So just to clarify that, please.
Through you, Chair, for clarification, we're not aware of any requirement to go through the legal portfolio of legal affairs. We aren't aware that ministries can't go directly to other law firms. So if there's something that we've missed, we've missed it, but we've not come across anything that says they can't do what they're doing. Thank you.
That's one of the good things that got washed out with the PMFL law. What I want to ask,
Looking at then recommendation number 9, just to close that off. Recommendation number 9 and also, well, recommendation number 10, where it says the government should develop standard terms and conditions for consultant contracts that ensure that its interests are protected and it is able to achieve value for money. Now, the responsible entity is given there is the Portfolio of Legal Affairs and the Central Procurement Office. And it also says in recommendation 11, the government should develop guidance to help identify which contracts should be reviewed by lawyers or be subject to legal advice prior to signing. And again, the responsible entity there is the Portfolio of Legal Affairs. And then in recommendation number 12, it says the government should ensure that the legal department has sufficient capacity and tools, such as standard checklists, to carry out the legal review of contracts consistently. So in essence, within these recommendations, we have placed a lot of responsibility on the Portfolio of Legal Affairs in terms of reviewing contracts and looking at contracts. And if that is the case, and which makes sense from a best practice standpoint, if that is the case, then as far as we are concerned, well, not just legal services contract, but all contracts should be at some point being signed off by the Portfolio of Legal Affairs, one on the legal issues, and similar to what we said in the Major Project Office hearing, that finance should also be looking to sign off also from value for money, because we already agreed that not the cheapest could be the best, but at the end of the day, we just want to make sure there's some balance. So within the government, we would expect a standard for all contracts requires some finance and some legal sign-off. So if that is the case and we're going down that road, then I think it's safe to say that we are putting some responsibility on the Portfolio of Legal Affairs to sign off on contracts. And I would assume it would cover all contracts. So there should be some provision there, which would make sense to have some legal review, but you can't have, and going back to the point that you made earlier, where if we're signing standard contracts that are given to us by suppliers, we're doing business on the supplier's term and not necessarily our term, and the only people who are equipped to fix that is the Portfolio of Legal Affairs. So we can't have it both ways. So it's either they have the responsibility to do it or they don't, but it can't be a recommendation. This has got to be a practice.
That requirement that be a practice is, has any progress been made on developing standard terms and conditions in consultant contracts across government?
We've not been approached by other entities, Mr. Chairman, since the Auditor General's report, that is, to provide any sort of standardization, if you like. It's something that we are happy to look into, but obviously that's going to require the input coming in from the other ministries or departments which are engaging consultants as well. We are very reactive, so if these things don't come to us, we're not in a position to offer any kind of legal guidance or assistance to them. And I appreciate that that's been one of the challenges that has been previously identified by the Auditor General. But in terms of next steps, whether anything has been taken at a wider government level, I can't say.
But shouldn't it be part of your remit as government legal advisors to put forth a suggested standard terms and contracts that should be in all of the so you're telling us that you've not been consulted by the procurement committee under the new procurement law to drop in a kind of standards that should be included in the contracts for procurement?
Not yet, Mr. Chairman, no.
Not yet. And the law came into effect Monday?
Monday.
And it's been on the books for what, a year? Which was supposed to provide for all of these things to happen. So we have no idea then that all of the fanfare that has been built up around this whole procurement thing, that it's going to make any difference. Because if the basic thing such as the procurement contract has not been vetted, or the legal department hasn't had input into and made suggestions of certain things that must be included in order to protect the government, what's the point? And where does your responsibility stop if you're the legal advisor of the government?
So 2 points to that, Mr. Chairman. As I said, I've not seen anything coming in from the procurement office just yet. It may be that that is imminent, because I know they are working on various guidance and policy documents that are supposed to be rolled out throughout government. So as soon as we hear from them, then we step into action. But in terms of the other consultancy agreements, as I indicated, it's a little bit difficult for us to do it in a sort of a vacuum if we don't know the types of consultancy arrangements that are being entered into by other entities.
There's certain language and certain areas that should be covered with any procurement contract. The specificity of the individual exercise on that individual contract. I can see that you have to wait for them to tell you what it is, but certainly you should be in a position to offer broad advice that these 10 things should be included in a contract that you're going to do in a procurement on.
I agree, Mr. Chairman, you are right. There are certain standard provisions that we can certainly do a checklist and provide to government. It would probably just take a little bit of work, because if you're doing a construction contract, on the one hand, that might have certain requirements. If you're doing one for the supply of other types of goods or services, that might be different. IT contracts, for example, for software or service level agreements are an entirely different species of agreement. So what you might have to put in there. So it would require identification or classification of the various types of agreements that we've seen, and putting forward a very basic list.
Right. You all don't see your role as the portfolio of legal affairs in government to offer advice unless asked.
I think we're happy to do that, but I think ultimately it comes down to resources as well, because it is a time-consuming exercise, Mr. Chairman, and that's the unfortunate reality of it.
You. Mr. Financial Secretary Representative, can you give us some idea why we're at the point of the procurement law coming into effect and we still don't have these kind of principles put in place as to what must be included in a procurement contract, and why you haven't asked the legal department to provide you with that advice?
Mr. Chairman, I cannot speak to the specificity of what is included in all of the new procurement law and regulations, but I can tell you that the Procurement Office has been working to ensure that issues such as standardization of terms and conditions of contracts are included. So I expect that if they haven't been issued as yet in terms of contact with the Portfolio of Legal Affairs, that will happen very shortly. So the Central Procurement Office has spent quite a bit of time and energy and effort in getting ready for the implementation of this new legislation. And obviously we want to make sure that this legislation is in place and government agencies are adhering to it. So the issues like contract standardization and processes and tendering procedures, et cetera, there's an education process that's actually ongoing right now within the core government.
How are you going to educate people when you don't know what it's going to be? The principle number 10 under the schedule for the procurement law says, legality, public sector entities shall conform to legal requirements. And if you're at the stage where the law has been brought into effect some 9 months to a year after it was passed by this legislative assembly, and nobody has approached the portfolio of legal affairs to get some kind of standardization. What I've been doing for the last 9 months, and the question is, how can you educate people on something that you have not made a decision to educate them on? That you're not personally responsible, so I'm not asking you to answer things that you may not have intimate knowledge of. But we have heard the expert in procurement on the radio, right, promoting the effectiveness of this law and how effective it's going to be and everything. And it is alarming at this point in time to be told that the Portfolio of Legal Affairs has not been consulted and intimately involved in making sure that these procedures are, that they're going to treat people are illegal. That's very worrying.
The thing about it, Mr. Chairman, just to expand on what you're saying, is that when you do look at the Auditor General recommendations, and I mean, going back to like recommendation number 10, for example, the government should develop standard terms and conditions for consultant contracts that ensure that its interests are protected and it is able to achieve value for money. The date of implementation is Q2, end of Q2 2019. But you have a law that has now come into effect the 1st of May 2018. So are we to assume that between the 1st of May 2018 and the end of Q2 2019, that there's anarchy in the procurement process?
Through you, Mr. Chairman, I don't think that's a correct characterization, Mr. Saunders. There are procurement rules and processes in place across government. Coming in with the new procurement law is to tighten those rules and requirements and to add more clarity and specificity, guidance essentially to public sector agencies on the best practice, what we would like them to follow in terms of procurement processes. This is new legislation. It is just coming into effect. There has been a number of education sessions going on over the last several months. In fact, they're still going on right as we speak, even though the law has now come into effect. From the Minister of Finance perspective, we recognize that there's still a long way to go because we've just pulled the trigger essentially on this new legislation, but we have to allow some time for government agencies to essentially start operating under the new arrangements. We are committed to monitoring their compliance with the new arrangements and to ensure we'll work with the Auditor General's office, but also internal audit and with the various chief officers to make sure that they are complying. And the Central Procurement Office is being equipped, staffed up essentially to provide guidance to all public sector agencies for any questions, any assistance that they may need in order to comply with the new legislation.
Yeah, but the issue that still remains outstanding is the fact that it is no law. I mean, the law is now in effect. So then the issue then, from what I'm understanding, because I wasn't here when it was passed, is that you put an effective date in for a new law that the government, in essence, would not have been able to meet. Because
the law said that the law will be brought into effect by a notice in cabinet. There is no reason for government to issue a date to bring in the law if they have not completed their preparation to implement the law. So if they have now put a date to implement this law with the knowledge that they don't have the necessary stuff in place, too straightforward and honest. I couldn't survive the bureaucracy that has now been created with the PMFL law, which is an ability to hide. And we went to, you're an accountant, you know the difference between cash accounting and accrual accounting. Secure accounting allows you to lie twice as much. See what the law says? This law may be cited as the Procurement Law 2016. The law shall come into force on such date as may be appointed by the Cabinet, and different times may be appointed for different provisions of this law in relation to different matters. And the Cabinet has issued a notice saying the law come into effect on May the 1st, 2018. It is reasonable for us, in the Public Accounts Committee, to assume that that notice would not have been issued unless the Cabinet had been convinced that all of the necessary policies and procedures were put in place, because this is 2 years old now, you know. Anyway, we digress. These when you have committed here to providing stuff in like the end of Q2 2019 for some of these standardization and stuff, are you in progress of having these things in hand, or are we going to run into another procurement law scenario when the time is up, you need another 5 years?
Mr. Chairman, just to clarify, looking at recommendation 11, where that reference to end of Q2 2019 is made, I don't think that was put in there by the portfolio, so I'm not entirely sure which entity that relates to.
For clarity, Mr. Chairman, committee members, it was a combined government response that came through the DG's office that involved all chief officers, to my knowledge.
Oh, okay. So you don't attend the chief officers' meetings on a regular basis?
I do, Mr. Chairman, yes.
Oh. And you don't recall these things coming up and commitments being made by the chief officers' committee, or whatever it's called, to have these things in place?
I don't recall this being done at a chief officers meeting. I do know that there was a request for various chief officers to provide input, but we'd put in our additional response, which is noted as specifically to PLA, and then we made reference in the date of planned implementation that we said it was difficult to estimate a likely implementation date for this recommendation. So that comment is quite specific to our portfolio.
So you're not in a position to recommend to the government by end of second quarter 2019 which contracts, what types of contracts the legal department should review prior to government signing it?
That was not the commitment that we'd given. However, we are happy to assist in that process as best as we can, and I anticipate that we should be able to meet that deadline, but we will certainly provide whatever assistance we can.
Well, you better find out who is giving these commitments and things that you're supposed to do. Okay, so these implementation dates really in here don't have any meaning then? Okay. Any other questions? Huh? Yeah, we don't want to impregnate the legal department with any political considerations now, do we?
Mr. Chairman, this is me.
Yeah, sure. You know, go ahead.
This might be repetitive here, but I do have a question on the business cases. When the Auditor General's office reviewed 3 of your department's contracts, none of them had a business case to justify the need. What decision, what making process is used, taking into consideration value for money for consultancy services or legal advice in the absence of business cases?
Through you, Mr. Chairman. So, as indicated previously, the business case would usually be associated with some sort of an open competitive tendering process, which, as I've indicated, we don't adhere to for the use of consultants. And the reason for that is generally the uncertainty of when a need for a consultant might arise, as well as the urgency in responding, which doesn't lend itself to any sort of protracted procurement process. So for that reason, for those legal consultancies that we have, there would not be business cases. Moving forward, however, one of the things that... Sorry, Mr. Chairman.
Not to interrupt you, but that's really not acceptable to the Public Accounts Committee. Because again, this is not a one-off thing you're doing. So you should have some kind of a business case and check system that you follow for these consultancies. Unless you want to change the name of them and call them additional lawyers, because consultancies tend to give a different connotation than what you seem to be recruiting, because you seem to be recruiting lawyers that you don't have in-house for particular legal cases.
And just for clarity, when we refer to business cases, they can be on a spectrum from quite simple and straightforward justification for the need through to something incredibly extensive that you'd expect for a big capital infrastructure project. So we're not expecting a massive, but we are expecting justification. We expect that just as much as does the procurement requirements for a single source arrangement as we do for any sort of contracted out arrangement, because it's about justifying the need.
A quick question, sir, before we move on. Just from my understanding, when these things are being processed for payments, these entities, I mean, what evidence or what support and documentation is being used to say something was approved or this spend was approved? Because there's a set process to be followed. And I mean, I hope it's not just a case of someone printing an email and signing on it, that this is what was agreed. So I'm trying to understand now, from a support and documentation standpoint, what justification is given or what is used to make these payments.
And through you, Mr. Chairman, through the financial audits that we're currently undertaking, we always look at supplies and consumables and things that are bought in and the processes and systems of control around it. For smaller entities, it can be difficult to get a segregation of duty, i.e. more than one person involved, but we always expect there to be a proper system in place and a proper segregation of duty. And if there's not, those are the sorts of things you'll see coming through in the management letters, ISA 260 points that we make to those entities. And there are examples we've found through this financial audit peak where there haven't been proper procurement processes in place. I'm hastening to add, this is specific, absolutely not relevant to the portfolio of legal affairs, but as a general comment.
And Mr. Chairman, if I could just touch on that point raised by the Auditor General's office. In terms of the business cases, I'm grateful for her sentiment that she's not expecting a sort of elaborate case that you would tend to find for a capital project. But what we've recognized is that for audit purposes, it's good practice to have something. So moving forward, one of the things that we are looking into is to having some sort of a justification statement. While we understand the basis and the need for an external counsel from time to time, it certainly would not be difficult to actually just have that recorded in sort of summary form, identifying the need and sort of the thought process that we've gone through to get to that stage. And I think that would be very consistent with their best practice.
Can you give us a time frame to put that rule in place? Next Friday?
Maybe the Friday after that, sir.
Not just... By the end of the next quarter, I mean, whatever, we need a commitment from you.
Certainly by the end of the next quarter, Mr. Chairman.
Okay.
No, I just want to just thank, just on a side note, for coming down here today. I know sometimes these things aren't easy with, with all of the different questions back and forth. But I just want to wish you guys luck, but just reiterate what I said open, that where we are concerned is that the legal department plays a very important role, similar to that of the Ministry of Finance when it comes on to procurement. And we just need to make sure at the end of the day that you guys, one, also recognize that, and two, get your house in order, so then we can start beating on other guys to get in order. Because we need you in finance tight so we can get other people in line. But because I can tell exactly what would happen. They will come down here and they'll throw you guys under the bus. They will do it. I'm telling you, it's just human nature. You know what I mean? So that's just one of the things I just wanted to make sure that you guys at least get your house in order, your procedures and everything else, because the entire civil service is relying on you guys. But outside of that, I just want to say thanks for coming.
Not to leave on a sour note, but we tabled a report in February in which I believe we made a recommendation that we expect that before any contracts are signed, there is some legal review, whether that is by somebody appointed by, agreed by your, by the Portfolio Legal Affairs. Question I have is, has anybody contacted you to find out how you're going to respond to that recommendation in a government minute, which is due 1st of June? The 90 days will be up, I believe.
Mr. Chairman, I have no knowledge of that, and I'm not aware of anybody attempting to contact me in that regard.
Well, I would invite you to contact the, I guess it would be the Deputy Governor, who is responsible for gathering a commitment from government and a response to the government minute, in response to the Auditor General's and the Public Accounts Committee recommendations, because we are likely to ask the Auditor General to review it in about 6 months to find out whether you have implemented it or not. And the standing orders of this Honourable House require that government respond to the PSC and the Auditor General's report within 90 days of it being tabled in the Legislative Assembly. And the response is not whether they're going to implement it or not, it's how it's going to be done.
Mr. Chairman, just for clarity, could I just ask you to repeat the specific recommendation that had been made?
To the best of my knowledge, the recommendation is that all contracts that are signed by government are reviewed by the Portfolio of Legal Affairs or by somebody appointed agreed by the Portfolio of Legal Affairs to do so before they're signed.
And Mr. Chairman, is there any threshold in place in relation to the value of the contract that needs to be reviewed, or is it all contracts across the board?
Well, we would expect that some contracts would be just standard, and you would have reviewed it, and we would expect that if you agree that that's the form they should use, that they would have the respect, shall I put it that way, to use that contract. But certainly in larger procurement, particularly those that are handled by the Procurement Committee, that those contracts have legal sign-off.
Thank you, Mr. Chairman.
Thank you. Thanks for coming. Break for lunch and come back at 1 o'clock. Thank you all very much.